This guy who claimed to be a disabled veteran, turned out it wasn't true that he was disabled. He was a veteran, but he was not disabled. And he was apparently coming in his old 1970s van all the way from Apple Valley, which is a substantial drive down the hill, to go shop at various Redlands businesses. Many of them aren't even open to the general public, but he sued them anyways for handicap parking violations under the ADA. And essentially it's a shakedown. They get paid $4,000 to $10,000 on every case, and there's not much of a defense. Either you complied with the ADA requirements, you don't, and this guy was shaking them down. Well, I don't do that kind of line of work. I don't want to be involved in that kind of work. There is a place for the ADA, and being my wife being recently injured, it's pretty hard to get around when you can't walk too well with either crutches or a wheelchair. And so it's certainly an important thing. But the shakedown businesses where you're not even really a customer for money doesn't sit well with me. Every unmeritorious case, every billboard lawyer that files a frivolous case, that affects me and what I do for a living, because the general public gets a distaste for plaintiffs' attorneys. In particular, they can't separate us from those ADA shakedown artists. And so I helped come up with a battle plan to help to defeat this one particular plaintiff. And quite frankly, I'm pretty devious when it comes to that stuff. So I researched this guy. We actually ended up getting him disqualified under the law and identified as a vexatious litigant because he filed like several hundred lawsuits. Not only was he determined to be a vexatious litigant, which bars him from filing lawsuits without getting permission from the court, but also we got him, as a matter of law, deemed not disabled for the purposes of pursuing those cases.